Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. We are back here in 2026, a new year. Ann and me. Ann, of course, is a law professor at the University of Colorado who teaches and researches securities and business law, and she minds the legal end of the podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Happy New Year, Ann.
Happy New Year, Mike.
Was it quiet? Was it lively? Did you go to a rave on New Year's Eve?
I did not go to a rave on New Year's Eve. I did not even stay up till midnight on New Year's Eve.
We made it.
I am old and boring.
We made it to midnight, but we were just at a party at our kid's house. And we kind of left at, I think, 12:02 after we said, and I think we mentioned, we're new grandparents.
Oh,
so we
congratulations.
So we spent some time with the kid and enjoyed a little bit of New Year's, but otherwise it was pretty quiet. So, and I'm guessing yours was too, eh?
Mine was pretty quiet. Yes.
All right, great. Well, let's talk about a couple of subjects today. We need to catch up on Tesla.
Sadly,
of
yes.
course, sadly, or whatever. I think we have what we can describe as some sort of closure, at least on the Musk pay case. There's many strands to this, but the Musk pay case we can kind of close up.
We can close that one up.
And I think it closed up in a way that I think it's fair to say we didn't exactly anticipate.
No.
Or didn't see coming. All right. So we'll talk about that.
And we'll follow up to stuff we've talked earlier about when we talked about what activists are up to right now. So now we're going to look at how activists actually recruit director candidates for a proxy contest.
Yes, that's sort of going on.
I keep waiting for someone to call me, but surprisingly.
Oh, we could do that. I didn't know you wanted to do that. Oh.
I don't think anybody wants to know. That would be a very poor fit.
Well, I mean, and assuming your deans would let you.
Let me. It's just, I think that would be a bad
I'll have to
idea
keep
for
that in
everyone
mind.
involved.
Oh, that'll be interesting. There'd be some activists that would love to talk to you. But let's keep that in mind when we get to that subject a little later. But for now, we have to remind listeners about what?
Our mailbag. We have an email address. Please feel free to reach out if you have questions for us or stuff you want us to talk about. Shareholder primacy, one word, at freefloat.llc.
Right. All right. Let's plunge into it. Let's plunge into Tesla, our favorite case study for all things governance and securities law and other stuff. And it came up again at the end of last month. This almost was like kind of got snuck in.
December 19th, which I'll remember because it was also the date that the Epstein files were supposed to be released. So
interesting.
Which one is distracting?
Yeah, I think, if they were hoping that the Tesla Delaware Supreme Court ruling would kind of overshadow the Epstein files, I think, and take attention away.
It might have been, I think it might have been the other way around.
Yeah, right. So anyway, so there's a couple final decisions that have been reached about that pay package. And just to remind everybody, that was the one from 2018 that was going to grant him, originally 50 some billion. Now it's probably closer to $100 billion worth of stock, captioned Tornetta v. Musk. So let's kind of recap that and sort of see how that finished out, shall we?
So it was going to, as you say, it was supposed to award him all this stock if he managed to meet these goals, the most ambitious of which had to do with increasing Tesla's market capitalization. And he was able to do that. He increased Tesla's market capitalization extraordinarily from 50 billion to around 650 billion. But after a trial, Chancellor McCormick held that this pay package actually violated the board's fiduciary duties to Tesla, because Elon Musk controlled the board. That's what she found. They were beholden to him. So he basically dictated the terms of his own pay package. It was never really independently considered by the board. And when the shareholders voted on it, they weren't given full information. And because neither the board nor the shareholders had really considered this pay package, there was really only one person left to decide whether it was fair to the company, and that was the court. And
that was Chancellor McCormick.
That was Chancellor McCormick. That's how it works. That's how it did work. And she held that it wasn't fair, partially because Musk didn't need that kind of award to be incentivized to increase Tesla's market cap. He already owned like 20% of the company. He didn't need an additional incentive to bring the market cap up.
That was kind of my thing as a Tesla shareholder, is that it's sort of the marginal additional benefit to Tesla shareholders of this stock was asymptotically approaching zero.
Yeah.
Because he was going to continue to work as hard or not work as hard as anything.
And that was also what she found, that he had said, like, he wasn't planning on leaving Tesla. He wasn't going anywhere. This wasn't necessary. Anyway, so that's what she concluded. And she decided that the appropriate remedy for this breach of fiduciary duty was rescission, to rescind the grant. So she basically took it all away. And, after that.
Well, and can I ask about that real quick? So
Yeah.
For them to rescind it basically means put the parties back where they were.
Well, this becomes
the day before.
Exactly.
Okay.
Well, that's what ultimately become the focus of the Supreme Court holding. But right. So, but what she said was, I'm rescinding the grant. Just rescind the contract. Just make the contract go away. It's as though it was never there. And now he doesn't have his $100 billion worth of stock.
Right.
Now, of course,
that was the substance of Chancellor McCormick's decision that was then appealed.
That was
to
then
the Delaware
appealed.
Supreme Court. Okay.
But of course, while the appeal was pending, we had a bit of a political
all sorts of shenanigans,
storm.
all sorts of bullshit went on.
Elon Musk went on this revenge tour against Delaware. He persuaded shareholders to reincorporate Tesla out of Texas. And then, of course, as we've said several times, into Texas. And then, as we said several times, the whole controversy kicked off a sort of wholesale rebellion against Delaware from a lot of boards.
Right.
I don't think that it wasn't this decision alone that did it. It was more like this was the final straw, because of a sort of growing sense that the Delaware courts had become too critical of managers, and there were a lot of threats that other companies were going to leave the state. Some actually did leave the state, which ultimately led to the legislature passing this new statute, which we have discussed, to dramatically loosen.
And that was
SB
21, I think.
SB 21.
Yeah, right. Okay,
so
got
this
it.
new statute makes it much, much less court review of conflict transactions like Elon Musk pay package.
Right.
But the new statute, though, going forward, it means that courts will just not be as involved in reviewing this kind of thing. It didn't apply to the pending case.
Right, because that case preceded the law.
Exactly.
The statute amendment.
So,
okay.
So the case was going to be decided under the old standards, and McCormick's decision was appealed to the Delaware Supreme Court. So when the Delaware Supreme Court got hold of it, they had this political hot potato. Because I feel like on the one hand, first of all, they were working with this old law, which is no longer going to be the law going forward anyway. And on the one hand, if they got into the facts and they overruled her and they said, oh no, McCormick was wrong. This board was totally independent of Elon Musk. They negotiated completely independently.
The facts just don't.
Nobody would have bought that. I mean, it would have been ludicrous. It would have made them a laughing stock. I mean, you didn't even have to read the facts of her decision to to understand that this is a board that's captured by Musk. So there was no way they could hold that. But on the other hand, if they affirmed her and withheld Musk's pay and agreed that his pay would be withheld, that just would have added more fuel to this fire, maybe reignited more companies threatening to leave. So they're in this incredibly difficult position. And we get this decision.
So and I'm guessing the position was truly objectively difficult for the Supreme Court.
I think it really was. It really was. And so they came up with, their solution was to say absolutely nothing, but still give Musk his payback.
So what do you when you say absolutely nothing? What, you mean they didn't have anything to say about much else about McCormick's ruling?
They found the most incredibly technical grounds to reverse it. I mean, it's very hard to read this opinion in any way, but other than they were looking for a way to reverse her by saying absolutely nothing in order to get rid of this political problem. It's the legal equivalent of a hostage video. You blink twice, it marks up.
Oh, I see. So you can just let's explore for a moment those technical grounds. I think it's worth mentioning. So, and it had to do with rescission, right?
Yes.
So what did that look like?
Well, no, I mean, to understand, remember, most of this appeal, most of what the plaintiffs and the defendants were arguing about was whether Musk did, in fact, violate his fiduciary duties to Tesla, whether the shareholders appropriately ratified his conduct. That was like...
Yeah, there are all sorts of really delicious legal and factual issues that came up.
Whether this was, in fact, a violation of fiduciary duties.
Yeah.
The Delaware Supreme Court didn't rule on that question. They didn't even acknowledge that the question was before them.
Oh, really?
There was a breach of. They didn't acknowledge, like, if you act like, if they look like question presented, the question, they don't even acknowledge that it is before the court whether Musk violated his
or whether he was
duties,
independent, whether he
controlling
controlled,
shareholder.
whether there was fully informed.
As far as they were concerned, that wasn't even before them. But it was before them. There were briefs and everything. Instead, the court held that, assuming there was a fiduciary breach here, and they're not saying there was, assuming there was,
right,
this remedy of rescission where you take back the entire pay package, that was not appropriate. Why? Because rescission, as you said, the legal remedy of rescission as a technical matter is supposed to mean that you restore the parties to their original positions. You take the contract away and you put them back where they were before the contract was entered into. And that wasn't possible here because there was no way to restore Tesla and Musk to the positions they were in 2018. You can take the money away, but you can't turn the clock back to 2018. So rescission, which is a particular remedy with a particular legal meaning, wasn't appropriate. Now, here's the thing. The court acknowledges there are other remedies that could have been awarded. Disgorgement, which means you make Musk give back ill-gotten
Oh, interesting.
gains.
So stop right there. So disgorgement and rescission
are different things.
Well, wait a sec. Legally, they're different things, but financially, to an economist and a Tesla shareholder like me,
they would be identical.
Fundamentally the same.
They would be. Well, it depends. I mean, if you thought the entire amount was illegally gotten, or whether you only partially. There's also a concept called rescissory damages, and it's for exactly this situation where rescission isn't feasible because you can't put the parties back to where they were, but the plaintiff. So instead you award damages to try to make up for the fact that you can't put the parties back where they were. But the court said the plaintiff didn't ask for these things. The plaintiff didn't ask for disgorgement. The plaintiff didn't ask for rescissory damages. The only thing they asked for rescission. Rescission is technically not the right word you should use.
Oh, wow.
So therefore, the plaintiffs get bupkis. So, I mean...
And that's a technical term, too, isn't it? That's in Black's legal dictionary? Bupkis?
Yes.
Yeah, okay.
So this is all very silly. The Delaware Supreme Court had plenty of discretion to award some alternative amount or to remand to McCormick to determine an alternative amount, and they chose not to.
And I think they wanted to be done with this at this point.
They wanted to be done. And the part of the opinion that really stands out is the second half dealing with attorney's fees. So McCormick awarded like $345 million in attorney's fees, but that was based on the idea that Musk's entire pay was rescinded. So if his pay was restored...
Oh, because as a percentage or whatever. We've talked about that with Grunfest and
exactly.
Joel, right, about how attorney fees work in this kind of stuff. Okay, go ahead.
She awarded $345 million, but she took it as a percentage of the value of the grant when it was awarded in 2018. Which was, as an option, was like $2 billion. So the idea was that she awarded pay, $345 million, which is I think the largest.
It's been a lot of money for those lawyers.
Yeah, but on the theory that they had won this extraordinary award for the plaintiff. The entire grant was rescinded. But so if his pay is restored, then you have to ask, what should the fee be? Now, keep in mind, if there was no fiduciary breach, if the plaintiffs are just wrong, the Tesla was fine, the board was fine, the shareholders ratified it. If the plaintiffs are wrong, the plaintiffs don't get a fee. You don't get attorney's fees.
Right, they lose.
They lose. But instead of even deciding whether there was a breach, the Delaware Supreme Court said there should be a fee, but it's a fee that compensates the plaintiffs at about 4 times their hourly rates
or whatever.
Yeah, so like $60 million. Now, something like that. So $60 million, that's a lot of money. Tesla shouldn't have to pay $60 million if there was no breach of fiduciary duties. And Tesla's board absolutely argued that there was no breach of fiduciary duties. But they didn't weigh in on this question. The court said Tesla has to pay $60 million in attorney's fees. So that's why this opinion comes up.
Oh, because didn't they say there was like $1 of nominal damages or something?
Yeah, exactly. They said that with rescission, there's $1 of nominal damages. But again, without acknowledging that actually the question of whether there was any damage, whether there was any breach was before them.
They didn't do any analysis, didn't look at that at all.
No.
Right.
So the Delaware Supreme Court was caught in this catch-22, and they came up with this holding that doesn't set any precedent because future plaintiffs aren't going to just use the word rescission, probably has zero implications for future cases, but still manages to placate all those companies that were threatening to leave by giving Musk his payback.
So they kind of threaded this needle here.
Yes.
In a fairly, based on what you've said and based on what I've read about, in a fairly deft way. Assuming,
No,
I mean, legally, this is highly questionable. But in terms
that's
of
exactly,
the overall environment,
well,
they,
it solves their political problem, whether you call it debt or not. I mean, like, it's not like we can't see what was driving this decision. And so what it really, in some ways, says is Delaware can be threatened and the court can be threatened. So,
Yeah.
I mean, for example,
and that's disappointing. That's
disappointing.
sad.
And one of the things about it that I've pointed out is that it's per curiam. So
What's per curiam?
Per curiam is it means it's an opinion that's not signed by any one justice.
Normally, this is like a five justice panel or something, right?
It's all five justices.
So what happened
deciding.
Here? Yeah.
And normally, a normal court opinion is actually authored by a particular judge, and the others join it. And so you recognize this is a Strine opinion, this is a Laster opinion. Well,
so they all kind of sit around and say, okay, you're in charge, you write it, and we'll sort of endorse it.
Exactly. It's assigned to one justice, and that justice writes it, and the others, maybe they nitpick in the process. Maybe they'll say, well, I'm unhappy with that sentence. Can you change it?
Right.
And when they're all on board, then they sign it. And if there's a dissent, that's separate. But per curiam means it's not signed by any one justice. It's issued by just the court. And usually when an appellate court like the Delaware Supreme Court issues an opinion, when it does per curiam, that's usually for hyper-technical rulings, insignificant rulings that aren't precedential. But this is a case that had global attention. And they still issued their ruling per curiam. No justice put their name on it. It's like they're not even trying to hide how much politics is playing a role here. Let's
make this go away.
Yeah, and I mean, I want to just identify the elephant in the room for me on this. So
please.
Handing Musk $100 billion,
right?
It's much more significant than simply making a CEO very rich. Money on this scale, this is wealth that gives him public power. It gives him political power. It gives him global political power.
Right.
That shouldn't be the case. It shouldn't be the case that just because we run a car company well, suddenly you can influence.
And he doesn't even do that
affairs.
lately, but okay.
Well, yeah. That is a separate issue. But just because you run a car company, you shouldn't suddenly be able to influence global political affairs. But that's what it means. That's the world we live in. And that's not Delaware's fault. It's not really Delaware's responsibility to address, but it's the background reality that the court was operating against. And look, I don't know the justices personally, but if I'd been strong-armed into giving Musk that kind of political power, I wouldn't put my name on that decision either.
Oh, I see your point.
When history looks back,
so the per curiam wasn't because they wanted to evade responsibility for this questionable legal
I wouldn't want my name. I mean, I don't know. It's not like they're confiding their thinking in me. I'm just saying, if it were me, if I didn't stand behind the ruling legally, if I weren't like, this is just the correct legal ruling, so let justice be done, though the sky may fall. Right. If I felt like I'd been strong-armed into it, I wouldn't want to put my name on that either, especially given what Elon Musk might do with the political power. That
well, exactly. He's been fairly quiet about this. Well, I mean, he cheered it, but it's not like he was all over the place.
Yes, but
about the case, absolutely right.
No,
he's all over the place on. Yeah. But in terms of the outcome here, I think he kind of took the W.
He tweeted and said
thanks and let's move on.
Well, I start fights, but I finish them, and then that. Yeah.
Right. So he now has it's roughly 300 million shares, and it's in the form of options that he hasn't exercised yet. So those are sitting there on the books. I think he actually filed a form for updating his holding and they should. And
he forfeits now that interim award that the board gave him to replace the pay package and all that.
And I suppose the lesser problem for Tesla shareholders was that alternate pay package was going to cost us a ton of money. It was going to cost him a ton of money in taxes. It was going to cost us a ton of money in accounting charges, and that's all been avoided. Yes. Because the original accounting charge was like $2.5 billion to award him what's now worth about $100.
Tesla definitely, they had promised, they had planned to give him back the money either way, but this is definitely better for Tesla if they give it back to him this way.
Right. But this is clearly a loss in some sort of broader sense. First, in getting some clarity legally about what it means to control and what it means to get approval. There was all sorts of really interesting stuff that I suppose
the laws changed.
The law changed it, but I suppose
Yeah.
they let stand a lot of Chancellor McCormick's reasoning.
Yeah, but it hasn't been reversed. But I'm just not sure that it matters anymore because SB 21 sort of gets rid of a lot of the law.
But then there's the broader themes about what it means kind of for Delaware's role in kind of distributing power between investors and executives, and that's unfortunate.
Yeah.
Yeah. All right. Wow. Per curiam. That's like the curia, like at the Vatican, right? Is it probably the similar root?
Don't know the Latin.
Anyway, all right. That was insightful. Why don't we take a quick break, shall we, and talk about how guys like me recruit activist candidates? Shall we do that?
Okay.
We'll do that in a minute here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we are looking at how activists recruit director candidates for an activist project. So actually, yes, how do activists find people to run for a board election?
Well, it's worth saying that how the process and the thinking there has evolved. Now, this kind of came up after you and I talked some weeks ago about kind of what activists are kind of up to right now. Which is, doing filings. There's a whole bunch of proxy contest cooking. There's I just counted, there's 7 that are pending right now as of Jan 1 or roughly. And then there's a whole number that'll be announced. And part of those, of course, is finding director candidates to be on your, as we say, a slate. And you'd think it's pretty easy, right? That this is, serving on a board of directors is supposed to be kind of cushy, right? You want to do it.
Yeah,
you want to make. Go ahead.
I'll mention I have a friend of mine a professor who studies boards, and he's done a lot of research on boards. And he said that people used to come up to him and ask him how they could get a board position. He's like, I don't know. I just study this. Like, yes,
I just research it. I don't actually go through the process. I mean, you want to do it, right? The average board count.
It's not for the money. Actually, I would love it from an educational standpoint for me.
Right.
But that's a really bad idea to put me on a board.
Don't downplay the money.
Reason. Well,
money at an S&P 500 board.
I am very aware.
Somewhere in the range of
actually I just
$200,000 to $400,000 a year to attend, 4 or 5 board meetings in person. Yeah. Mostly a few committee meetings, which you can usually do virtually. It's a lot more work than it used to be because of the litigation and fiduciary risk than it was
and also
20, 30 years ago.
I think a lot more. There's been more regulatory matters that have been put on.
Yeah,
the board
but
level.
still,
so,
you got to sit through.
I'm not saying that it's not a full-time job either way.
No, it should be really kind of good, except. Activists are a little different, as I'm sure you've learned in your interactions with me over these past years. Because, let me point to a couple of dimensions of an activist project. First, of course, we're dealing with turnarounds. We're dealing with, companies that aren't just smooth sailing where you can go to 4 or 5 board meetings a year and a few committee meetings. Yeah. There's a lot of work. Sometimes you're recruiting a new CEO. Sometimes you're getting into, weekly or meetings about how the business is going. Mm-hmm. You're retaining investment bankers for and supervising them for strategic reviews. There's a lot more work and a lot harder work than it might otherwise be.
Right. Okay.
And then furthermore, working for an activist or on an activist slate used to be kind of career ending. At least if your career involved getting on boards.
Right. So,
because
you position yourself as being opposed to boards, so now boards
right.
don't want to.
You're not a go-along kind of person. Yeah. Sorry. You're willing to ask a lot of nosy questions and not accept baloney answers. I mean, that's kind of the nature of that kind of thing. And I think all boards obviously should behave that way, but in particular, activists.
If they're challenging the board, they're not going to. I mean, I think we've said previously, like, I was surprised to learn that Exxon is still really upset that investors challenge them with director candidates.
That's right. So anyway, so that used to be a big problem. And so activists for a long time would be, kind of calling around.
The fact that you wanted to do it meant that you could do it in a way. If you want to be on a board, then you can't. Yeah, I see.
Right, or if you wanted to be like recruited by a nominating and corp gov committee, once they saw that you'd even, been at some point in the past on an activist slate, they'd move on to the next person. Well, that's not quite true anymore. We'll talk about that in a minute.
Okay.
Because activist projects have become more acceptable, obviously, relative to past years. Working on, especially if you kind of do a really, workmanlike job of trying to help with the turnaround, help recruit a executive, help, deal with the sale of a business or something like that. Those kind of skill sets are still, kind of valuable. And to be able to show that, if you show it in an activist project, well, that's okay. So just as activist investing has become a much more acceptable way of allocating capital in the past, call it 10 years, serving as a board candidate for an activist investor is also become a little more acceptable. Again, not completely, okay, and it depends how you comport yourself in some ways. But it's not quite the career ender that it used to be. Okay. But then we get to the question of exactly how do you do this? If you're like me, what do you do?
Where do you find people?
Right. Well,
and presumably we're talking now about. We're talking about members that you're talking about as being independent. Your pitch to the shareholders is they are independent of me. They're just well qualified, and they will
with a caveat on there, because the first level of independence is independent of the company.
Right.
Okay. But then there's also kind of independent of the activist.
Right.
Which sometimes has its appeal.
Right.
Yeah,
I mean,
There are shareholders that value that want to vote for directors that really aren't trying to express the interests of just one single shareholder, but will kind of represent all shareholders.
And it might be like a difference of like what your theory is of the problem with the company, presumably.
Sure, absolutely, right.
So there are some hedge funds, they'll put the hedge fund guy on the board, and sometimes they'll recruit independents saying, look, I just think they need an outside person to look at the books.
They need someone who's completely apart from this. But the first place I usually go, if I'm advising somebody or whatever, is to say to the shareholder, the investor, the portfolio manager, would you consider being the director? Would you consider being the either one if they're looking just for one seat, or the whole, or the first of many, of several. And there's this reason for that. First, of course, one of the downsides is, you're not necessarily independent in the way that we were just talking about. But when a portfolio manager does this, it sends a couple of very important signals. Okay. First, the most valuable resource that one of these folks has, if you're, Nelson Peltz or Jeff Smith, is your time. And if you're willing to spend the few hundred hours a year that's required to deal with a turnaround situation, that sends a really important message to your limited partners, to other shareholders, to the company, that this is enough of a priority that I'm going to spend a lot of that valuable time on this one company in what presumably is a at least modestly diversified portfolio.
Right.
Okay. So that I think has a lot of credibility. It also helps, that we always talk about having this kind of ownership mindset on a board. Well, having someone who's got, if you're a D filer, at least 5%, at least if it's either your own money or you have fiduciary duty to that money, that really is, there's no better way to demonstrate that kind of investor mindset than putting that person on the board. But nonetheless, sometimes portfolio managers, they'll decline. There's blackouts and there's trading restrictions, and sometimes they like to be able to trade around the position. You can't do that real easily if you're on a board. Or we get to the independence issue that you identified, which again, and I've had these conversations with people where they say, it may not look kind of good to other shareholders whose votes we're trying to attract.
Because they're afraid that, I'll run the company to benefit my particular fund strategy rather than a different strategy.
Right. And again, as hard as that kind of becomes, if you're just one or two people on a board of, 6, 8, 10, but still the optics around that sometimes are challenging. So you get to other things. The next thing I do is go ask other shareholders, are there candidates that you would love to see on this board? Okay, so if you go to, if I own, I don't know, make them a number, 4%, then I go to someone who's got 9%, who's otherwise just passive, G-filer, and say, is there someone that, maybe you don't have a person within your shop that would like, but is there somebody who you'd like to see? And they say, it's kind of funny. I knew a former executive who would be perfect for this. If you do that for 2 or 3 shareholders, you really start to, pardon the expression, lock in their support for whatever you're doing.
Right. Okay.
It's a great tactic for trying to find people in a way that builds some trust and the spirit of collaboration between yourself and these other shareholders. Now, again, you got to kind of word this carefully to make sure you're not, forming a group with that other shareholder. But that's technically feasible. You could sort of say, is there someone that you'd like to see?
If you haven't made an agreement, then if they haven't promised,
right, exactly. Anything, just if you're looking for suggestions, that having another large shareholder suggest someone doesn't mean you have to do it.
Right.
It just means that you're.
And they haven't even promised that they've lived for them. It's
right. Exactly. So that's another step. Then there's a couple other places to go. There are activists that have increasingly started retaining search firms to do this.
Now, is that?
Go ahead.
Well, are there concerns about confidentiality with that kind of thing?
Not really. I mean, no more or less than any other kind of search. The couple that I know, there's at least 2 search firms. I don't need to mention them here, that have a bit of a specialty in advising activists, and they kind of understand some of the issues we've been talking about, and are really good at collaborating with an activist, kind of understand the mindset. Of course, that costs some money. And, again, you do risk a little bit of, losing some of the edge you might have if word gets out that there's a search firm looking for candidates for a certain kind of board. But that's what's nice about that. That's a very professional way of doing it. You'll get to possibly some candidates you might not otherwise find. And you can kind of do it systematically in a way that, you might not be able to do if you're just a portfolio manager that's doing what I would label next is like calling your friends.
Right.
So that was kind of the time-honored way of doing this, and activists used to do this. The night before a letter was due, they'd be calling around saying, "You want to be on a board?" Those are in the bad old days.
Right. We all know what the problem with the call. Yeah, you ask your friends. I mean, leaving aside everything else means that the same
just
group of
find
people
some, and that was kind of the warm body theory of trying to do this, and again that still happens some. And what's nice about that is if you're, talking to people that you've worked with before in various things, there's a high degree of trust.
Okay.
One of the big problems that happens all the time with this kind of stuff is some activists, it happened at a couple of companies I worked on years ago. Excuse me. Some, activists will, recruit a director. We'll get to, in this one case I'm thinking about, we settled with the company, we put the director on the board, and they immediately got co-opted. They immediately got captured by the board. And no longer were the independent voice, questioning.
Well, that happened to Air Products, Air Gas thing, which is I love telling students about
exactly.
that one.
So that's much less of a risk if you're just working your own network, and calling your friends. And part of the problem with asking your friends is there's other shareholders that may be looking for certain expertise. So if maybe you have a certain kind of media company you're working on, and you don't have many friends in that business, but you find somebody and then who you can trust, but nonetheless other shareholders say, oh, that guy doesn't have any experience in streaming or whatever the business is. So finally, there's this whole long list now of executive networks. There's women director networks and minority and all sorts of director networks that you can kind of go to. That would be, there's so many more people now than there used to be, and it's so much better organized in terms of trying to find candidates. And if followers here want to know some of them, I've worked with a couple, and they're really good. There's a lot of really good candidates, people that present really well. You can get 5 or 10 people and winnow it down quickly to who you need, and that also works pretty well to get to these director networks. So there's a series of steps you can basically go through that I've gone through to try to find people to do this kind of thing. Just to recap, starting with yourself. Again, that's if you can get over the independence issues,
right.
That usually sends the right kind of message to a lot of people if you're willing to do this. The only other comment I'll make is this has become a lot more important under universal proxy. Kind of how you recruit candidates and what they look like and what their credentials are and their background and their experience and so forth. Because as we've said before, under universal proxy, director elections are much more individual, incumbent versus challenger.
And you're targeting a particular person, so you want to make sure that you have the exact matchup.
Right, exactly. So if your thesis is we need to sell the company or we need to sell this division or something like that, and there is absolutely no expertise on the board that has any kind of deal experience. They don't know how to retain a banker. They don't know how to price a deal. They don't know how to negotiate a deal or whatever. And we have 2 candidates here that are really good at that. That really supports your thesis really well. Now, then you got to get in this stylized example, then you have to assume shareholders like the idea of selling whatever you're trying to sell there. But because the comparisons are somewhat more person to person and direct, this whole recruiting process has become a lot more critical than it ever was. And so, the days of, we do it a little bit, calling the night before a notice is due, trying to see who's available. Still happens, but usually there's a lot more planning that's gone into this. As a matter of fact, right around now, first week of January, a lot of this stuff's kind of baked in at this point.
Okay.
A lot of director candidates that are going to be put forth in the coming months have pretty much been identified, roughly following the process that I've outlined here. Okay. So that's kind of how that works. Isn't that interesting?
That is interesting.
So now here, Ann, you want to be on a board. You want to get another 300K.
That would have me is that.
You'd be, look, your knowledge of law and corporate governance and so forth is surprisingly scarce on boards.
Okay.
There are boards that have practicing lawyers, that are more like deal-oriented kind of folks.
Right.
And they tend to be retired. Most boards would not have an active outside counsel or whatever. And you may have a general counsel from another company serve on a board. That's unusual. But having an academic law professor on a board could be kind of good. So everybody who's following, if you're looking for directors, you know where to find her. How's that sound?
Yeah, I'm right here.
All right, great. Why don't we leave this be for now, shall we?
Okay.
And wrap up?
Okay, absolutely.
All right, and we can come back next week and find more good stuff to talk about.
Sure. Well, It'll be more active.
Right, exactly.
Once we
all right, this is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I am an independent activist investor and advisor to investors about their activist situation. Ann is professor of law and the Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School and a prospective director for your activist projects. You can find me, Mike, at theactivistinvestor.com and Ann at law.colorado.edu. Our podcast is produced and distributed by Free Float Media. Welcome to 2026. Thanks for listening, and we'll talk again soon.